I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Xenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay.
Pursuant to the, I guess.
I understand.
That we literally had one after the other, like a rung on a step ladder. One. Yep.
And
so let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Xenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may.
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was located.
What?
They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant pushed a complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
But he has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's an older case.
At that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're a 0.1 mile away from the location. For what?
Well, okay, I get that. But so we've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, hey man, I'm going to slap her. So at that point, I mean, that's what we have.
Okay.
Right? Mr. Xenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant, and then they find there was something else. Was there another warrant that you said?
No, it's the aggravated assault, but Judge.
Crimes related to resisting an officer or interfering with the performance of public duties. The mere fact that a defendant does not cooperate with an officer or shows fear or stress during the encounter does not constitute an intentional act to obstruct the officer's duty. Intent, in this context, means that the individual deliberately and knowingly acts to disrupt the officer's lawful duty, rather than reacting out of anxiety, confusion, or lack of awareness of the situation. For example, physical or verbal resistance aimed at preventing an arrest or the execution of an officer's lawful order may constitute a crime, but mere non-cooperation or silence by the defendant does not. Furthermore, If an officer's actions during an arrest or investigation are outside the scope of their legal authority, any evidence obtained from such actions is legally inadmissible. In other words, even if the defendant behaves in a way that the officer perceives as interference with public duties, if the officer acts beyond their legal powers, that evidence cannot be used to convict the defendant.